cargo is carried under a bill of lading governed by the Hague or the Hague-Visby Rules. It's discharged by the carrier and remains in the carrier's custody in the port area. It's then delivered by the carrier without production of the bill of lading and pursuant to a letter of indemnity, an LOI, provided to the carrier by the charterer. A fairly common situation. Usually there's no problem and the cargo is delivered to a person entitled to it. But not always. The cargo may end up being misdelivered to a person who's not in fact entitled to it, and the carrier may therefore end up facing a misdelivery claim brought by the bill of lading holder. Can the carrier claim the protection of the Article 3, Rule 6 one-year time bar in the rules in respect of such a claim? In the Alhani, decided in 2018, which was a Hague Rules case, David Foxton QC, now Mr Justice Foxton, held that it could, at least where discharge and delivery took place at the same time. That was a tanker case, where discharge and delivery, and therefore misdelivery, occurred simultaneously at the flange, and therefore within the so-called Hague Rules period of responsibility from shipment to discharge. David Foxton specifically left open the question of whether Article 3, Rule 6 would protect the carrier for misdelivery after discharge, by far the more common case. In FIMBank and KCH, the giant ace, the gap left by the Alhani fell to be addressed in relation to misdelivery post-discharge and a bill of lading which was governed by the Hague-Visby Rules. The arbitrators, and then the commercial court, held that Article 3, Rule 6 applied in such a case, and that was today endorsed by the decision of the Court of Appeal. The claimants facing the time bar argued that Article 3, Rule 6, whether in the Hague or in the Hague-Visby Rules, did not apply to such a misdelivery because the rules only regulated the period of responsibility from shipment ending with discharge. The Court of Appeal disagreed. The Court's reasoning on the Article 3, Rule 6 question proceeded in two stages. First, the Court looked at the Hague Rules themselves, the original Hague Rules, and the Court held that on the true construction of the language of the unamended Hague Rules, on balance, as the Court put it, the better view, as the Court put it, was that Article 3, Rule 6 did not apply to misdelivery after discharge, but only in relation to all liability of any kind whatsoever on the part of the carrier, which arose during the Hague Rules period of responsibility between shipment and discharge. However, at the second stage of its reasoning, the Court of Appeal held that the position was different under the Hague-Visby Rules. The very wide language which was adopted in the amendment of the original Article 3, Rule 6 by the Visby Protocol supported, in the Court's view, a textual conclusion that the new rule was intended to apply even in cases outside the sphere of application of the rules. Interestingly and significantly, the Court had regard, under Article 32 of the Vienna Convention on Interpretation of Treaties, to the travaux préparatoires, which explain why that text was changed in the Hague-Visby Rules. And the Court of Appeal held that there was no room for doubt, and there was a clear bullseye, as Lord Justice Mayles put it, in choosing a time limit deliberately expressed in the broadest possible terms. The drafters plainly intended that the limit should apply to misdelivery even occurring after discharge. As he went on to say, it is unlikely in the extreme that they intended the time limit to apply to misdelivery occurring during the voyage or simultaneously with discharge, but not to the typical case of misdelivery occurring after discharge. And therefore the Article 3, Rule 6 time bar in the Hague-Visby Rules applied. The claimants had a second string to their bow. They argued that the parties, by Clause 2c of the Congen Bill form, which says the carrier shall in no case be responsible for loss or damage to the cargo, howsoever arising prior to loading and after discharge, was a complete code, which meant that there was no room left for Article 3, Rule 6. The Court rejected that argument too, in circumstances where it was the claimant's own position that the clause would not cover misdelivery. In such a case, the Court of Appeal held that there was a clear reason for Article 3, Rule 6 to continue to apply. The Court of Appeal today refused permission to appeal. The Alhani gap has therefore now been closed, both for Article 3, Rule 6 of the Hague Rules. Article 3, Rule 6 will not apply to misdelivery after discharge, and for Article 3, Rule 6 of the Hague-Visby Rules, where Article 3, Rule 6 will apply to it, given that that was the specific purpose of the change that was made. Thank you.